I think companies are inclined to over-collect data, and even inadvertently, this is the worst AI is going to be right now, and it's doing incredible things in that sort of fledgling state. A lot of the concerns or skepticism around AI, similar issues were raised around email. I mean, ultimately, our profession figured it out, and now obviously the use of email is secondhand. It's mandatory.
Welcome to Between the Briefs, a podcast by Steno. We're here to bring you practical tips, expert insights, and real conversations about the pretrial process, court reporting, and the legal technology shaping the future of litigation. I'm your host, Adrian.
And I'm your host, Joe Stevens. Whether you're an attorney, paralegal, or just curious about how technology is changing the legal industry, we've got something for you. Each episode will break down complex topics, share behind-the-scenes intel, and talk to the people leading innovation in and out of the courtroom. So grab a coffee and let's get into what's happening between the briefs.
Hello and welcome to Between the Briefs, brought to you by Steno. We are your hosts. My name is Adrian.
And I'm your co-host, Joe Stevens.
In this episode, we're excited to welcome Patrick Austin, Cybersecurity and Data Privacy Counsel at Woods Rogers. Patrick is a recognized leader in the field of technology-driven legal services, specializing in data privacy, cybersecurity, and artificial intelligence. He brings a wealth of knowledge, including advising on incident response, compliance, and the intricacies of tech transactions.
Patrick has a host of certifications, as well as being a fellow of Information Privacy. Patrick's expertise has made him a trusted advisor to clients in high-stakes matters. He has also worked with organizations on navigating complex privacy laws and understanding the intersection between AI and data security.
Patrick, welcome to the show. It's an honor to have you with us here today. How are you doing?
I'm doing well. Thank you so much for having me.
Of course. So I want to start off at the start of it all. Where did your career begin? What one made you want to go into, cybersecurity and law?
Yeah, so I graduated law school in 2013, attended George Mason up in Arlington, Virginia. After graduating law school, I worked at a small boutique law firm handling workers' compensation cases. Didn't really like that. And in 2015, I joined the Department of Justice, specifically in the Office of Information Policy. And that was an incredible experience. It was sort of my first foray into information security. I was specifically tasked with reviewing administrative appeals related to the Freedom of Information Act and Privacy Act. So basically, if someone was to submit a FOIA request to a government agency, they didn't like the response, I would be the person who'd step in and review how that request was handled. And that gave me some insight into sort of how personal information is protected, managed, and how sort of even mundane pieces of personal information like a telephone number, an email address, if it winds up in the wrong hands, sort of the risks and potential damage that could be inflicted on individuals because of that. For example, one of the most common FOIA requests that I reviewed when I was at DOJ was requests submitted by federal inmates who'd been convicted of some pretty heinous crimes, and they were submitting FOIA requests asking for the home address, the telephone number of the prosecutor who convicted them. So you can imagine, those are some pretty sensitive requests, and obviously we've not released that type of information, but it just shows you that, sort of information that you may enter online at Walmart to get a discount code, if it's in the wrong hands, could actually wind up, causing some serious harm. So that's what led me into working in this area. I then transitioned into the private sector around 2023 and focused more on data privacy and cybersecurity. And I will say my background in FOIA at DOJ is now actually paying dividends in the private sector because, we have this hodgepodge of state privacy laws, right? But I think we're up to 20 now. And all of these state privacy laws now have data subject requests where individuals can go to a company and say, please give me all the data you've collected on me. They have the right to request, deletion of their data. So it's almost like we're witnessing the FOIAtization of private sector records. So definitely, the background and experience I've had at DOJ was really helpful in what I'm doing today.
That's fascinating, Patrick. So going from DOJ to private practice, is there a sort of a single or maybe a couple of misconceptions that companies have about how the government approaches cybersecurity?
Yeah, I think, in terms of just government employees in general, when I was trying to transition from the government to the private sector, it was tough, candidly. I still have a spreadsheet of a bunch of law firms that I applied to and never heard back from. And I think it's because I think firms have a hard time, understandably, seeing how government work translates to private practice with, developing a portfolio of clients and business development. And I think it's also just this misconception that government employees don't work as hard as people in the private sector, which is a complete falsehood. I really had the privilege to work with some of the hardest working and brightest people when I was at DOJ. So I think it's definitely, some challenges when you're trying to make that transition from the public service to the private sector.
I'm curious, you mentioned how sensitive data can easily be released, right? And even the smallest things that we may not consider to be sensitive, such as like maybe our phone number or email, how quickly we can give it to one party and it could be leaked to multiple other parties. What kind of advice would you give anyone listening when it comes to protecting their data and how they go about it?
Yeah, I think definitely for individuals who are sharing their personal information with a company, they should go in with operating under the assumption that that data is going to be attempted to be monetized or analyzed at some point, maybe even just optimized for that company's use and benefit. I think the old saying goes, if the product is free or the service is free, then you're the product effectively. So, I mean, that's what I would advise people is going in, understand that if you're providing your email address, phone number, even your home address, that information may be shared with third parties, not in a nefarious way at times, but just, for business operations purposes. But also if you're feeling skeptical or concerned about your personal data, again, as I mentioned, exercise your opt-out rights. You have the ability now, depending on the state you live in, to go to the company and say, look, I don't want you to share my personal data with your marketing company that's based in another part of the world. So please, delete my information. So if an individual wants to do that, they certainly are empowered to do so.
So on that note, maybe if I double down on Adrian's question or make it a little bit more bleak, what kind of privacy time bomb do you think is sort of like lurking right now and how businesses are using customer data?
Yeah, I think, and I know it's a topic we'll touch on is AI, and I think it's almost more of a matter of time when one of these AI companies suffer a cyber incident, and what troves of data are going to get accessed. I think it's more of an if than when, or more of a when than if. And as it's widely known that most of these AI models, especially with the larger companies like OpenAI, NVIDIA, they are basically consuming the entire internet. And so tons of personal data could be maintained and is being used to train these large language models. And if that gets exposed to a bad guy, that could really be a significant incident.
I can definitely see this the incident kind of looming, because I've seen so many data breaches happen over the years, and it almost feels kind of inevitable at this point. It's like another big one is going to happen as this landscape continues to develop. So, how can businesses kind of protect themselves on the legal front when it comes to when they receive data from their customers? What can they do to make sure they're not in a bad position for either a breach or getting sued for misuse?
Yeah, so I think it's definitely the need to be proactive and not reactive. And so I think I typically advise companies if they're trying to strengthen their cybersecurity posture, definitely develop first strong protocols when you're accepting data. So multi-factor authentication is a key. Trying to do data minimization is important, which basically is a principle saying only collect the data you actually need to complete a particular service or send out a particular product. Then there's also just being prepared, for the worst case scenario. So have an incident response plan developed, one that's actually up to date and current, that identifies and lays out the steps that you're going to take in the event of a data breach. Have cyber insurance coverage. Have a cyber incident response team within your organization. Identify the key stakeholders like your CISO, your chief technology officer, your legal counsel, and make sure that they understand that they're going to be sort of the go-to team in the event of a large breach. And then also finally understand your breach obligation notices, right? I mean, every state has a notification statute on the books. It basically says if a data breach occurs, depending on the severity of the breach, you may have a notice obligation to send out letters and provide credit monitoring to consumers. So you got to be prepared to handle that.
I'm interested in the dynamic there, though, because obviously I can't imagine that anyone would disagree with what you just said, right? Like that, the value of being prepared and out in front matters a lot. But then there's when the crisis is actually upon us, that's usually when people sort of realize how far behind they are in their preparedness. And I'm curious about how you then sort of explain, really convince the value of this compliance or being prepared to executives or teams or
who really just see it maybe as a cost center, or why are we taking it this seriously? Why are we expending this much effort when we haven't really been met with the crisis just yet? Maybe this is just a general question around preparedness on any front, but particular to privacy. I'm interested how you convey this, the intensity and the severity of it.
Yeah, no, it's a great question. And I mean, something I encounter quite often is, especially post data breach, is a company saying, we just never thought we would be the target of a hacker or some, ransomware group, and I always tell them that the size of the organization is not really material at this point. There's so many threat actors out there that even small businesses, mid-sized businesses are at risk of suffering a pretty significant breach. So don't assume that just because maybe you're, a smaller company that you're going to avoid getting, hacked at some point. And again, be proactive and not reactive. So having those protocols in place and those security guardrails in place is going to help mitigate that risk going forward.
I'm curious, with your background at the Department of Justice, what type of safeguards did you see or did you help put in place to make sure that American citizens' data is really protected and people can feel secure knowing that the government's got your back when it comes to data security?
Yeah, so fortunately, especially in the context of the FOIA and the Privacy Act, there are specific exemptions in place. There's actually sort of a set of 9 standard exemptions that basically says the government, if they get a request for records, they can point to that exemption. They don't have to release a particular piece of information. For example, exemption 1 is the national security exemption. So if it's related to national security records, classified materials, that information does not get released generally. The example I've read earlier around personally identifiable information, there's exemption 6 and 7C in the FOIA, which specifically address sort of personal data of non-public individuals, right? So there's a distinction between a FOIA request for, let's say, the Attorney General's, personal information, or, something like that, or as opposed to a career civil servant who's just working in a DOJ component. There's a heightened privacy protection. And so those are sort of the more common exemptions that I was able to sort of apply during my time there. 6 and 7C, by far the most common sort of exemptions applied to protect the personal information.
Patrick, are there industries that are real leaders in the way that they sort of handle and secure this data? Are there industries that are surprisingly lagging?
Yeah, I think healthcare is a big one. Considering the sensitivity of medical records, personal health information, as we just saw last year with the Change Healthcare data breach, which I think affected basically everyone in the United States. It highlighted the sensitivity of the data that can be accessed, and really the havoc that can be wrought when there's a significant data breach. I mean, there were hospitals and doctors who were trying to figure out how to make payroll because Change Healthcare was shut down for, I believe it was 2 months after a cyber incident. So it's the largest data breach in the healthcare industry in U.S. history. So that's just sort of emblematic of something that's unfortunately quite common, where a lot of threat actors target hospitals, medical centers. And at this point, there needs to be, I would submit, stronger safeguards to protect that information, because it's so sensitive. It's your personal medical records, it's your health history, things of that nature.
I'm curious, what's the solution here? Because I studied a little. That was my degree in healthcare systems, and I know that electronic health records are basically in the hands of just 4 major companies. Right? You got Epic, you have Oracle, and a few others. So if these companies aren't really talking to each other to achieve complete security, what is the solution for protecting consumer data?
Yeah, it's a great question, and I wish I had a clear answer for you. I think unfortunately it may get to a point where, right now it's more of HHS has some enforcement authority, but I think they really need to, maybe Congress will enhance that authority to drop some significant penalties or compliance violations, basically empowering HHS to really get the industry in shape and let them know that these types of preventable cyber incidents cannot be tolerated. At this point in time, it's more of sort of the bigger fish, larger hospitals might get hit with a nominal fine relative to the amount of revenue they generate. So I think if there's a way to try to resolve it, I think companies respond to guardrails. They respond to clear enforcement penalties. It makes my job easier, honestly. If a company gets hit with a sizable penalty, I can point to them and say, "Hey, look, don't be this company. Take the protocols now and take the steps to protect your data so you can avoid getting hit with this large fine."
Patrick, if we go back to AI for a second, everyone is obviously sort of swept up in how it's affecting and positively or disrupting whatever sort of industry they're in. What kind of take do you have on some sort of specific AI regulation that you might feel is in the best interests of sort of privacy and cybersecurity, but also might ruffle feathers in the tech world?
Yeah, actually, here in Virginia, we actually had a AI high risk developer act that was passed by the General Assembly and then vetoed by the governor. And his rationale for the veto was we don't want regulation to stifle innovation. And I think we're starting to see guardrails be put up at the state level. Colorado passed a comprehensive AI regulatory framework last year. It's going to go into effect in 2026. The European Union has the AI Act that's going to go into effect around the same time. So we're seeing sort of a general idea of what's going to be regulated and what's not. And it seems like the sort of takeaway is that there's going to be higher risk AI systems that are scrutinized, and maybe lower risk AI systems such as like ChatGPT would not be subject to a harsh regulatory regime. So I think that's something we could see going forward. More states embrace that sort of framework where higher risk AI systems, which basically are AI systems involved in making consequential or significant decisions in particular sectors. I think that could be a model that's used going forward.
I could definitely see that. And I could tell with the packs of some other privacy laws that passed, just as GDPR, what like domino effect that had on various industries and how they had to kind of model their own uh, just safeguards based on what GDPR recommended. When it comes to advising clients, right, they probably show you their whole business structure. What is one of the first recommendations you make to make sure that they are compliant or just start getting the ball rolling correctly?
Yeah, one of the first steps I always advise companies to take is map your data. Figure out where data is being collected, where is it going. I think one of your previous guests, Alex Shuristani, did a great job describing the fact that data isn't static. It flows from different departments. If you enter your home address email in a quick contact form, it doesn't go to just one person or go on a spreadsheet. It can flow to an operations team, a logistics team, a customer retention manager, CRM program. And so just taking the time to figure out, here are the data flows, here's where it's being collected, here's where it's going, can go a long way in assessing your compliance obligations and figuring out this is this specific law I need to comply with. This data is being collected in this state, but you have to comply with this state law. So it's just a really important step. And a lot of companies don't do it, frankly, because it can be really hard. I mean, organizations that have grown pretty quickly can have siloed systems and departments. They may be relying on legacy tech that isn't sort of up to date. And so it can present some challenges.
These challenges that you're talking about, I mean, when we talk about, we were just talking about regulation, and you're talking about obviously now asking companies to map this very fluid data. I mean, how do you even? Is it always by definition somewhat reactive? I mean, how do you regulate? How do you really sort of like be fully proactive in a world where the iteration is just so rapid and the tech is, I mean, by the time a study is sort of performed on early models of AI models, it's already sort of like 3 versions out of date. I'm trying to figure out how all of the regulation and stays sort of apace with the actual innovation itself.
Yeah, I think just making a good faith effort really goes a long way, to be candid. I mean, I think you make a great point that a lot of this is sort of it's like a fire hydrant to the face. You're just trying to figure out, how to proceed. And so I tell my clients is, look, as long as you're taking the steps, you're trying to implement these security protocols, it can go a long way if you're subject to, let's say, a regulatory investigation. You can present the steps you've taken. It's really the companies that have not been doing anything or been sort of just ignoring this obligation that really get hit with a significant penalty.
So I think we're seeing right now with a lot of these companies, it's kind of growth at all cost. We're seeing safeguards kind of. We saw this with some early versions of ChatGPT, and when the government trying to create some intervention, saying, "Hey, we need some more laws in place so AI can be developed responsibly." What do you think companies like ChatGPT or OpenAI need to really consider ethically when it comes to the development of these AI models, especially when it comes to consumer data?
Yeah, I think adhering to the data minimization principle that's really codified in the GDPR and even the CCPA and other laws is really important, which is, collect only the data that you actually need to complete a task. I think companies are inclined to over collect data, and even inadvertently. I mean, they may have a third party vendor that they're relying upon to manage personal data, and they may not realize that, oh, we're actually collecting, geolocation data or specific sensitive personal information. So I think adhering to that principle, trying to enforce that, and then also trying to get adhere to privacy by design, which is basically consider privacy, have that be a part of the discussion at the ideation phase. Whatever new AI tool or application you're considering to develop, consider that privacy issue and have that discussion at the very forefront, and then bake it into the sort of development process for whatever tool or application that's being brought to market.
Makes complete sense. I want to do a follow-up question on that. And what do you think law firms can do to be proactive about this?
Yeah, actually, it's a great question because just last week I gave a talk at a state bar association. The topic was AI and legal ethics, and really open questions around attorney-client privilege, attorney work product, and using AI tools and applications. What client information should be put into an AI tool, if any, right? And really, I think looking at the rules of professional conduct is really important. That's sort of our guidepost right now, and it's sort of a duty of competence is really important. Understanding how these AI tools work, duty of confidentiality. So you have to have these safeguards. Law firms are ethically obligated to have security safeguards in place for personal data.
Um, on the heels of that, and what do you see as sort of like, how do you see privacy law evolving as a career path for that next generation of attorney?
Yeah, I think I expect more state privacy laws. Honestly, we're up to 20. I think we'll see more, mainly because there's just sort of a vacuum at the federal level. I don't think we're going to see a comprehensive federal data privacy law in the near future. So I think you're going to see more states take the lead on this, and it's only going to sort of expand the ever growing web of different privacy laws and regulations that businesses are going to have to navigate. It's interesting. I think it could help some of my clients because it would establish sort of a uniform set of compliance obligations and requirements that they could more easily adhere to, especially for companies that have a 50 state presence. It's really getting to the point where it's almost untenable to fully comply with all these different state laws that have nuances and quirks for each state. For example, the Maryland data privacy law, which is going to effect in October of this year, it's like Maryland went to California and said, hold my beer, we're going to pass the strongest, data privacy law out there. I mean, you can't collect information, sensitive information, even if you get the consent of the individual. That's how strict the Maryland law is going to be. So that's going to present some significant compliance challenges, especially for companies like, Amazon, other large companies that do business everywhere. And so I think a federal privacy law could be good. I don't know if well, here's the conundrum. I think as we've gotten these state data privacy laws in place, the states that have them in effect are actually now the strongest advocates for keeping a state-based model. Like, for example, there was a proposed federal privacy law last year that for a few weeks, it looked like it was maybe had some potential to move forward through Congress. And it was actually the California delegation that came out against it and said, look, we like the CCPA. We think other states should emulate this. We don't want a watered down federal bill that, takes away a private right of action and other requirements that are in the CCPA. So I think, honestly, as more states adopt these data privacy laws, you could see an even reduced chance of a federal privacy law going into effect.
Do you think that would increase consumer confidence in data protection? Because right now, I think it's even an ongoing joke. It's like Instagram already knows everything about me. I don't need to, every time I scroll, I already have the ad for what I was thinking, let alone what I was just talking about with a friend of mine. Or even the government, right? People always say, the government knows where I am. And they're probably not wrong. So do you think having like a federal regulation would actually increase consumer confidence or just create more confusion?
I think it has the potential it could create more confusion. And also, I think the bigger question is, how do we view the protection of personal data? Do people honestly care at the end of the day, right? I mean, I've talked to people who are like, look, as you pointed out, my information is already out there. If it gets used by a bad actor, so be it. I'll get free credit monitoring, and let's just move on with our lives, right? I mean, that's sort of the sentiment I see quite often with individuals when talking about these topics. So I think a global or a federal privacy law may help in some sense, but I don't know if it would actually change or push the needle either way for consumers.
If we made it personal here for a second, I'd just like to draw a tangible example, Patrick. Is there some sort of privacy or security practice that you religiously adhere to in your personal life that you sort of wish everyone did?
Yeah, when something I do, credit monitoring is absolutely essential. My personal information's been part of large data breaches. So I think I have like 3 or 4 different credit monitoring services at this point, offered by different companies. But then something I do is just have uh, personal information monitoring as well. There's companies that offer to sort of scan the dark web using your personal identifier just to see if there's anything out there. So I recommend if you want to do that, to take that extra layer of protection, considering one of those services.
That's a great idea. I actually don't think people get the full scope of what's possible when someone has their data. So could you walk the audience through like what would happen if a bad actor actually got your data and was trying to use it maliciously?
Yeah, so bad guys can do a lot of different things when they get access to personal data. Typically, they go to the dark web. They have a trove of data taken from exfiltrated from a company's website, and they basically put that on the open market. And they say, hey, other bad actors, pay me $10,000, 20,000, what have you, maybe even higher. And here's this data for you to download and use as you will. I've also seen bad actors who, once they get access to someone's personal data, actually reach out proactively to the consumer and say, look, I have your information. I hacked this company. Pay me and I'll delete it for you. So that's a new thing that's sort of going on right now. But it can definitely be used for nefarious reasons. Identity theft obviously is continuing to be a growing issue. So that's certainly the most common implication with a significant data breach.
When you're dealing with a client who seems to be sort of facing some sort of like, I don't know, a unique situation, impossible privacy requirement, whatever it might be, is there room in your world? Is there room in the work that you do? Like, is there a space for creativity in providing solutions, or is it really just a regimented sort of structure that people need to generally adhere to?
Although there's definitely a level of creativity, and that was one of the starkest changes from going from government service to the private sector. Is it went from case research to sort of business ideation and operational concerns. So it was more of company CISO comes in and says, hey, we're considering launching this new product, this new service, personal data may be implicated, chart out what we need to do to get into compliance with applicable law. And so it's sort of those hypothetical issues, those edge issues that come up quite often in the practice I'm in today, as opposed to maybe a more, case law based, here's the precedent, here's this statute that applies. It's more of a, uh, let's find a way to get to yes in terms of helping businesses, advance in their product development or their service development.
It sounds like there is a big client relationship there where you kind of have to nurture, ask a lot of important questions to get the full picture. Have you ever been put in a position, especially with large companies, where you kind of see the full picture and it's just a mess, right? When in terms of like how they're going about managing data, where it's going, safeguards in place. What do you do in that situation where, the client clearly has a major problem? You see the problem, but it is just insurmountable almost.
Yeah, I think as outside counsel at times advising companies where I've been in this exact same situation, I think all we really need to do is reach out to the company, explain the situation, advise them on the steps that they should be taking, and hope that they do it. And really sort of, I don't want to say it's a CYA protocol, but it really is providing as much candid advice as you can for them to implement. But ultimately, it's going to be their responsibility to take that advice and turn it into action. And so that's something I have seen before where I'm like, wow, you guys have been successful with this framework in place. And so, yeah, I think that's definitely just strongly encouraging them to implement those protocols.
Patrick, as you sort of scan back to the beginning of your career through now, and obviously the tech disruption that's going on with AI and whatever that means, are there skills or there knowledge bases that you were really focused on early in your career that you're less focused on now? Are there skills that you're learning now, or that you just would be shocked to have thought that you were learning right now? I mean, what does the evolution of your practice look like given the tech environment that we're in right now?
Yeah, I think if anybody's looking to transition into cybersecurity, data privacy, I would strongly encourage them to look at the International Association of Privacy Professionals and get involved with that organization. As you mentioned at the beginning, I have some certifications from IAPP, and I found those to be really helpful in terms of becoming a certified information privacy professional, becoming a privacy law specialist. So I think those certifications give you that sort of experience, or give you that background in terms of the technical developments that are going on within the industry, what's applicable in certain scenarios. And so if you're like I was, a mid-career professional looking to transition into data privacy or security, getting those certifications would be a huge boost.
You mentioned mid-career, you decided this is a good shift for me. What was that kind of light bulb moment for you, and why did you pick cybersecurity?
Yeah, so it was when the California privacy law went into effect, and then quickly thereafter, the Virginia Consumer Data Privacy Act went into effect. And I live in Virginia; that's where I practice. When that passed, that was sort of the light bulb moment. Where like, okay, data privacy is going to be a thing. This is going to be a viable career path, and there's going to be some new and complex issues that arise from this type of legislation. And so that's when I decided, look, I'm going to try and really make this shift, go into data privacy as a specialty. And fortunately, the light bulb proved true. There's a litany of states that followed the Virginia model, and basically have developed sort of that data privacy framework. And it's really been an exciting and interesting transition into this area of law.
You mentioned Virginia, California, Colorado, and Maryland, obviously. Is there a model country? Is there a model state when it comes to cybersecurity regulation?
Well, I think in terms of cybersecurity, I mean, every state has a data breach notification statute. Some states have more granular, specific cybersecurity requirements, like New York, California, have some pretty rigorous compliance obligations on the cybersecurity side. So really, again, it depends on when I'm advising businesses, where are you doing business? Are you operating in California, New York? That's when they would trigger those sort of more stringent cybersecurity obligations. Which honestly, if you're doing security compliance correctly, they're not that burdensome. It's like having a security system plan in place. It's having an incident response plan. It's identifying an incident response team, implementing MFA, as we talked about. If you're doing those things, then complying with New York cybersecurity's law or California's law is not that onerous, to be candid.
What would an emergency response look like in the case of a data breach, right? What's one of the first things that a company would want to do, especially when everything seems to be on fire?
Yeah, it's a great question. It's something I routinely encounter. It's executives who are, their head spinning. They're trying to figure out what's going on. They can't log into their computer, or their website is down. What I typically advise organizations is, first, call your lawyer. And I know I'm biased saying that, but honestly, one area where companies get into trouble is those 3 a.m. emails to their CISO or to another executive. That information's not protected by privilege. Once you get your attorney in, you can then possibly assert attorney-client privilege into those communications. So the sooner you get your attorney involved, that's really important in terms of protecting those internal communications about what's happened, what's going on, what should we do. Then in addition to that, I think doing a proper assessment of, is this actually a cyber incident that warrants escalating to our incident response team? Because a lot of organizations get a suspected incident, but they aren't sure 100% either way. It could be a hacker, it could be something else. So having sort of protocols in place to do that assessment, and then if it does trigger a cyber incident, escalating that to your incident response team, and getting those protocols in place.
You just talked about, the privilege, getting the lawyer involved, and sort of therefore triggering that privilege. As a practicing attorney myself, obviously one of the questions that I get a lot when it comes to AI use is, and you mentioned this also about the CLE that you just gave when it came to sort of ethical engagement with AI. Is there anything that practicing attorneys need to be concerned about and the discoverability of how they engage with AI? I mean, what do they need to be thinking about to ensure that their work product is not discoverable, when they engage with AI?
Yeah, no, one of the key questions that was asked during the CLE was, do I have an affirmative obligation to notify a client that I'm using an AI tool like a Gemini or ChatGPT service? Do I actually have to tell all of my clients I'm doing this? And right now, the ethical guidance says not necessarily. It's sort of it's more of a case dependent, fact specific analysis. But that's sort of a key question that needs to be addressed is, if you're using AI extensively, at what point do you have to get that's a disclosure statement in place and get client consent? I would say I would err on the side of caution. I think advising clients that, look, we use AI tools. This is the future. Uh, Getting some sort of general consent would be helpful just in terms of protecting your legal practice going forward.
Very cool. One thing I've noticed from interviewing lots of attorneys, paralegals, is the industry can be moves very slowly when it comes to adopting new technology. This might also be true when it comes to adopting new hardware. One big part of cybersecurity is having, firewall and a lot of this software and infrastructure in place that can actually protect you against any type of data breach. What do you think is a solution here for our industry when it comes to adopting new hardware, yet it's slow to actually want to bring that on and into their law firm?
Yeah, I think adopting new hardware is going to become, a prerequisite, especially as AI gets integrated more into our daily working systems. I think there's going to reach a point where you're having a legacy tech system that just does not work in today's world. It's almost like when you had the old school Macintosh or computer, and then you had the new Apple computer come out, and it's almost like, look, you have to make this transition into updated technology. So I think that's probably what's going to happen in the hardware context, that the current models are going to get so outdated that you just have to eventually bite the bullet and make that transition.
Patrick, when you're you obviously engage in this world from a legal perspective and an advisory perspective and erring on the side of caution and whatnot. Are you excited about the direction AI is taking the legal practice, or just in general how it's being applied? Or do you think it's still really important? I mean, this might go without saying. I might be answering my own question here. Like, are you skeptical? Are you erring on the side of caution in people adopting it? Or are you sort of saying, like, once you check a certain number of boxes from a security protocol or from an assessment or vetting or a competence understanding, like, have at it, go for it?
Yeah, I'm an AI evangelist. I think it's going to be akin to using, it's going to be like the internet. It's going to be something that we use on a daily basis. And I would tell people, if you're skeptical, keep in mind, this is the worst AI is going to be right now. And it's doing incredible things in that sort of fledgling state. It's only going to get better and more advanced and more nuanced. And so I think it's an important tool. And I think people should, again, be proactive and start implementing different AI systems in their workflows. So I think it's going to provide a tremendous efficiency gain, and free people up to do more complex and challenging work, especially in the legal profession. I think a lot of the more mundane tasks that attorneys are having to work with, like document review, contract review, there are some AI tools that can do that in a flash, and you're just the time savings is so incredible that it's a worthwhile venture into getting that integrated into your workflows. But overall, yes, very, very optimistic about AI going forward.
We are happy to hear that, because you can't really stop it. It is where it is right now, and it's going to continue.
Yeah. Well, I will say, word of caution: don't rely on ChatGPT to do case research and then submit that to a court, because we're seeing that. And when I read those cases, I'm like, man, I was skeptical for a minute there, but then, yeah, I think the benefits outweigh the risks. Just use it properly, honestly.
Well, Patrick, we always ask this at the end of our interview, and that is, what is your hottest take on the industry right now?
I think, and this is related to the last question, I think AI is going to be the biggest value add to the legal profession in decades. I think it's akin to the advent of using email. And I mentioned email specifically because a lot of the concerns or skepticism around AI, similar issues were raised around email. They're like, is it safe? Can we communicate with clients if it's going to be sent through the internet, through these different protocols? And ultimately, our profession figured it out. And now, obviously, the use of email is secondhand. It's mandatory. And I think going forward, the use of some of these AI tools is going to be very similar. It's on that similar path of being a valued tool that's used on a daily basis.
Wow. Well, completely agree. Great take. And honestly, thank you so much for joining us here today. It has been a fantastic conversation. And thank you to our audience for tuning into Between the Briefs, brought to you by Steno. Special thanks to our guest again, Patrick Austin, for sharing his invaluable insights in cybersecurity, data privacy, and AI, and his impressive journey in the tech law field. And of course, big thanks to my co-host, Joe Stevens, for another fantastic conversation.
Yeah, likewise, Adrian. I really enjoyed this one for sure. Be sure to subscribe so you never miss an episode, and stay tuned for more thought-provoking conversations at the intersection of law, technology, and innovation. We'll see you next time.
Up next on Between the Briefs.
I don't think that it's all about the future. I think a lot of it is now. When you're taking something to court, you're an attorney, and you haven't validated that it's still good case law, that's really not an AI problem, right? That's kind of an attorney problem.
Stay tuned for the full interview coming to you soon. Between the Briefs is brought to you by Steno. To find out more about Steno and how we combine exceptional court reporting and litigation support services to deliver a superior litigation experience, visit steno.com. That's STENO.com. And then make sure to search for Between the Briefs in Apple Podcasts, Spotify, or anywhere else you get your podcasts, and click subscribe so you don't miss any future episodes. On behalf of the team here at Steno, thanks for listening.